You remember yesterday I was here saying it was harsh, it was a bit harsh, and it was harsh. Charlie, Samson of Joy News has he has really educated us, and I think it's necessary for us to watch it. He addressed a whole lot, but after that I'll talk. So let's just watch it.
Now here is my take, and I do 5 minutes, or often I do less than that. Today I may do just a bit above that number for good reason. I titled my take, Akuapem Poloo. How is 90 days harsh? That's a question. Celebrities, properly called, have much influence, especially on the youth. It is expected that before you take on a course, you will seek professional advice if it is not a matter for common social commentary. Today, I ask or repeat your questions, mostly uninformed, and educate you over your hashtag Free Akuapem Poloo campaign. 1. You say that this case was concluded too swiftly because it was against a poor citizen. The law is against the poor. That's what you have been screaming. Well, maybe sometimes if you can't afford a lawyer. But did she have a lawyer? Yes, she did. She was arrested in July, appeared in court and pleaded not guilty and granted bail in November 2020. Why did she change her not guilty plea to a guilty plea on Thursday? Apparently, she changed her plea, obviously upon advice, after she and her lawyer had been, as required by law, served with the evidence the prosecution was going to use for the trial. Tell me if you were also giving those documents to examine, or what informs your loud protest that she should not have pleaded guilty. The evidence must have included her public admission and apology video. How was she going to defend that? Leave her lawyer alone, because it could have been worse if she went through a trial and wasted the court and everybody's time when she had a video admitting to the wrong. How many, and let me take that line again. How many issues have I dealt with so far? What did you want the court or judge to do after she pleaded guilty? So you can't be saying it was swift. What exactly do you mean by it was too swift compared to other cases involving prominent people? Which cases are you talking about, and who has pleaded guilty and their case has not ended because they are powerful, connected, or they are rich, as you claim? But when did it become the job of the court to go arresting people you claim must also be facing prosecution? Except for a capital offense, once an accused person pleads guilty, a judge is constitutionally and legally bound to convict and pass sentence. That will be swift. The court is the creation of law, and the judge works with the law. Why was she remanded into custody after conviction when she was already on bail, you ask? You really want the rules changed just for her. And why? A suspect has been brought to court. She pleads guilty and is convicted to wait for sentencing. And you are preaching the convict should be allowed to go home and not kept in the custody of the state? What will you think and say if she doesn't show up for conviction? If anything happens or he runs away, she runs away, is this how you want convicts to be treated? Stop spewing absolute ignorance without deeper thought or a scruple of principle. How can you keep a single mother away from her child for 2 days? You have been asking. Okay, granted she, in fact, is responsible for the child 24/7. You are saying this will be the first time she will ever be away from the child for 2 days or even a month or more? Do we have single mothers in custody, in prison in fact, or we let them go when they plead or are found guilty of an offense? Why is her case different? Get this. The law mandates a judge to order pregnancy tests for a woman convicted before passing sentence in the interest of mother and unborn child. The law mandates that if the test proves positive, the judge shall hand a non-custodial sentence or pass a sentence but suspend its execution until an appropriate time, meaning the pregnant convict does not go to jail. But if she commits another offense during the period, she will be made to serve both the suspended and the fresh sentence together. The judge, acting within the law, had the power to hand her the maximum of 3 years for the first offense only, then a maximum of 60,000 Ghana cedis or plus 2 years each for the second and third offenses. That's 7 years altogether. But she handed her 90 days for each offense. Even that, she ordered the sentence to run concurrently, meaning she serves only 90 days and not the total of 270 days. The court had the power, taking all the circumstances into consideration, to opt for non-custodial sentence of a fine plus a bond to be of good behavior or a caution. It is the court that was seized with the facts, and it must have been aware of your uproar and shouts decrying her conduct and calling for action when she first published those pictures. What hypocrisy of a confused generation in dire need of principles, a sense of decency, and a scruple of morality. You shouted, "Deal with her, she's been dealt with," and even leniently, and you say what? May the child survive the potential effects of what he was put through by her mother. If you must continue your campaign for freedom, now is the time, because a judge has no such powers to free a convict. The president wields the prerogative power of mercy to grant a pardon or reduce her sentence. If he is minded to do so in this case, I doubt he will want to contemplate that. Those of you preaching a wiser sentence would have been to put her to some work and public advocacy. There is no such thing as sentence to community service in Ghana. Get that. And finally, you're already preaching an appeal. Say they should appeal and get her on bail. Well, that in law is also an avenue, not social media. The law provides deterrence, which is not said by a fine in this case. Another judge may have handed her half or a quarter of the punishment allotted in this case to show even tougher love, which doesn't kill. 90 days or more is the punishment for this in many countries. May the lessons be learnt. But dear friends, by our new law, Cybersecurity Act 2020, a mere threat to circulate indecent image for whatever reasons, including blackmail or sextortion, attracts 10 years minimum and 25 years maximum in jail. A judge will have no discretion to give you less when you are caught by this law. If you want only fines, get to work now with your MPs and not the police or judges. That's my take.
So Akuapem Poloo could have even gone for like more than 7 years. Yeah. So this is not a light thing. You see, the thing is that we are in a country that sometimes we feel like the laws don't work. So when things like this come up, it seems very drastic. And the other thing is that if these kind of stuff happen and people actually take them to court, then it's an issue. But if nobody has taken them to court, it's not an issue. Yeah. If you haven't been taken to court, it's not an issue. So Akuapem Poloo's own, now I understand, is like an example for what the law actually stands for. Yes, I also listen to advice and I also accept rebuke. I've been enlightened concerning a whole lot and concerning integrity and discipline for our nation. Because then now we understand fully that it wasn't even anything compared to hash. Yeah. But then it's sad that she's in. Proverbs chapter 25 verse 12 talks about it, that a rebuke to the listening ear from a judge is like jewelry. Yeah, so we're done for today. Stay blessed, stay connected, stay safe.